Hello, Live Law viewers. Welcome to Courts Today. Let us dive into the important legal headlines of today. The Bombay High Court has today stayed a special court order directing registration of FIR against ex-SEBI chief Madhavi Puri Burch and other BSE officials. Centre has informed the Delhi High Court that a Uttar Pradesh woman on death row in UAE for an infant's murder was executed on 15th February. Supreme Court has reprimanded a lawyer for threatening suicide if adverse order was passed and has sought written apology from him. The Supreme Court has stayed recruitment process of judicial magistrates in Gujarat without minimum practice condition. The Chhattisgarh High Court has said that legislature must relax rigid conditions under Section 45 of PMLA to allow room for bail determination on case-by-case basis. The Apex Court has flagged rising vacancies in district judiciary leading to trial delays in district courts. And the top court has commuted death sentence of a father who killed his two children. This is your host Urvashi Chauhan bringing you the important legal updates of the day, quick, crisp and to the point. Please watch this video till the end, and if you find this update valuable, then do not forget to like, share and subscribe to our channel. The Bombay High Court has today stayed the order of a special court which directed registration of an FIR against ex-SEBI chief Madhavi Puri Burch and whole-time members and also the top officials of Bombay Stock Exchange. Let me tell you, journalist Sapan Srivastava had filed a complaint alleging that top officials of SEBI and BSE, including Madhavi, were involved in fraudulent stock market practices. He claimed that they knowingly allowed the illegal listing of a company called CALS Refineries Limited and failed to take action against its wrongdoings. Srivastava and his family had invested in the company's shares back in 1994 but suffered huge financial losses. He alleged that SEBI and Bombay Stock Exchange officials ignored the company's fraud, manipulated the market and did not protect investors' interests. Taking the complaint seriously, a special court found enough evidence to suggest a criminal offence and ordered the Anti-Corruption Bureau to register an FIR and investigate the matter under corruption and stock market laws. Burch and other officials had subsequently approached the Bombay High Court seeking quashing of this matter. Arguing for SEBI whole-time member Ashwini Bhatia, Solicitor General Tushar Mehta told the bench that special judge had failed to apply his mind, especially to the fact that the petitioners were the present office bearers, while the alleged listing of the company took way back in 1994. Today, single judge Justice Shiv Kumar Dighe of the Bombay High Court, after hearing their arguments, stayed the special court's order, saying that the same was mechanical and was passed without going into details and without giving opportunity to the respondents to file their side. Hence, the order has been stayed. In the next update, the union government has informed the Delhi High Court that an Indian woman, a resident of Uttar Pradesh who was on death row in Abu Dhabi for alleged murder of a 4-month-old child, was executed on 15th February this year. The woman was awarded death sentence in July 2023 and the same was upheld by the court of second instance there. Since then, she was languishing in the jail. The woman's father had moved a plea before the High Court seeking a direction on the authorities to inform him about the exact current legal position and well-being of his daughter. As per the father's plea, in 2022, the woman had obtained a visa and travelled to Abu Dhabi. She was employed as a caregiver by a woman there who had given birth to a boy. After the infant passed away, a purported video recording was obtained in which the woman was alleged to have confessed to the infant's homicide. Though the Indian woman had appealed, but it was dismissed and her death penalty was upheld last year. According to the father, he got a phone call from his daughter on 14th February. She told him that she was being moved within the facility and was about to be executed. It seemed like the call would be the last time she could talk to him. Worried for her, he sent a request to the Union Ministry of External Affairs asking them to check on her legal status and safety. But since he did not get any response, he filed this petition to find out if she was okay. During the hearing, Additional Solicitor General Chetan Sharma informed Justice Sachin Datta that the woman was executed on 15th February and that her last riots will be held on 5th March. Sharma also informed the court that arrangements were being made to enable the woman's family members to travel to Abu Dhabi to perform her last rites. Upon hearing this, the court orally remarked that the situation was very unfortunate, and with this the father's plea was disposed of. The top court has expressed shock and disapproval after a lawyer threatened to commit suicide during a hearing. The lawyer was seeking to quash a criminal complaint filed against him by another lawyer. A bench of Justices Abhay S. Oak and Ujjal Bhuya strongly condemned the lawyer's behavior, stating that if the court quashed the FIR against him along with the one he filed, he could commit suicide. The court recorded its shock at such conduct from a member of the bar. The bench directed the lawyer to submit a written apology and an undertaking promising not to repeat such behavior. The court clarified that if he failed to do so, legal consequences would follow. The case here stems from a dispute between two lawyers in Tamil Nadu over an alleged assault in the year 2017. The petitioner had filed an FIR against another lawyer, the president of a local bar association. In response, the other lawyer filed a counter complaint leading to legal proceedings against the petitioner. The Madras High Court had dismissed the petitioner's plea to quash the case, prompting him to approach the Supreme Court. During the hearing, Justice Oak sternly warned the petitioner, stating that the court would not tolerate such conduct from a lawyer. He further warned that if the petitioner threatened the court, an FIR would be registered against him and the Bar Council of India would be directed to take action which could lead to suspension of his license. After the matter was passed over, the petitioner apologized, stating that he was emotional. Justice Oak instructed him to submit a written apology, after which the court would dispose of the case. The court has now scheduled the next hearing for Friday, when it will consider the apology. Moving ahead, the top court has stayed recruitment process of Judicial Magistrate First Class in the state of Gujarat. The court expressed dissatisfaction with the Gujarat High Court allowing the recruitment process to proceed without any requirement of a minimum number of years of practice as a lawyer. For context, let me tell you, in January this year, the Supreme Court reserved its judgment on the issue of whether the condition of 3 years of practice at the bar in addition to a legal degree needs to be restored to appear for the Civil Judge Junior Division exam. This was in light of various issues faced by high courts in terms of lack of exposure on the functioning of courts. Let me also tell you, this requirement was done away with the Supreme Court in All India Judges Association case in the year 2002. The advertisement issued by Gujarat Public Service Commission in this case did not prescribe that the candidate should have any qualification of minimum number of years of practice as an advocate. The bench of Justices B.R. Gavai and A.G. Masih observed that the High Court should not have allowed the recruitment when the top court is seized of the issue. It has therefore issued notice to the Gujarat High Court as well as State of Gujarat. The court will hear the matter now on 18th March. Stay tuned. Moving further, the Chhattisgarh High Court has made an important observation about the strict bail conditions under Section 45 of Prevention of Money Laundering Act. The court said that the law should be made more flexible so that judges have some room to decide bail cases based on individual circumstances. Right now, the law is too rigid, making it difficult for lower courts to grant bail, which results in many minor bail cases reaching to the Supreme Court. Justice Arvind Kumar Verma, who made these remarks, said that while serious cases involving money laundering linked to terrorism should be dealt with strictly, not all cases are the same. However, the law currently treats all accused under PMLA in the same way, which is unfair in less serious cases. He also pointed out that while the government's efforts to fight money laundering and terror funding are necessary, sometimes the rights of accused individuals are being compromised due to the inflexible nature of the law. For your information, let me tell you, according to Section 45 of PMLA, bail can be granted to an accused in a money laundering case only if twin conditions are satisfied. That is, there should be prima facie satisfaction that the accused has not committed the offence and that he is not likely to commit any offence while on bail. The court here was hearing the bail plea of Anwar Debar, who is accused of being involved in a major liquor scam in Chhattisgarh. He is the elder brother of Raipur Mayor Aijaz Debar. The prosecution alleged that he misused his political connections and ran a liquor syndicate, taking illegal commissions from liquor suppliers. It was claimed that he worked closely with top bureaucrats to manipulate liquor production and supply, earning huge profits in the process. Debar's lawyers, on the other hand, said that he had no direct involvement in the crime and that ED's investigation was biased. However, after reviewing all the evidence, the court concluded that he was a key player in the scam and was in possession of illegal money generated from the crime. Thus, his bail was denied. While discussing the strict bail conditions under PMLA, the court pointed out that Supreme Court has mostly focused on the seriousness of the crime while upholding this provision. However, The High Court suggested that the law should not have a one-size-fits-all approach and should differentiate between different levels of offences. With this ruling, the Chhattisgarh High Court has once again sparkled a debate on whether the strict bail conditions under PMLA need to be reformed. While the fight against money laundering remains crucial, the court has indicated that justice must also be balanced with individual rights. A bench of Justices Bela M. Trivedi and P.B. Varale was today dealing with a suo motu proceeding initiated in relation to addressing systemic flaws under the POCSO Act 2012. The court today raised serious concerns about the shortage of judges in district courts, which is causing delays in trials, especially in cases under the POCSO Act. It said that while special courts have been set up to handle POCSO cases, they are now struggling due to lack of judges, making it difficult to implement Supreme Court's directions for speedy trials. During the hearing, senior advocate V.V. Giri, acting as the amicus curiae in this case, informed the court that several directions had been issued to ensure faster trials, such as appointing special prosecutors and training legal professionals. However, Justice Bela M. Trivedi pointed out that while the necessary infrastructure exists, there are simply not enough judges to handle the workload. She highlighted that judicial vacancies remain unfilled across states, making it unrealistic to expect timely justice. The bench also discussed possibility of seeking updated reports from states on POCSO case pendency. But Justice Bela Trivedi remarked that courts are already overwhelmed with monitoring various cases and further directions might not be practical. The court ultimately decided to hear the matter again on 25th March but did not pass any new directives to the high courts. And lastly, the top court has commuted the death sentence to life imprisonment without remission of a man accused of killing his two minor children. The court reaffirmed the principle that a death sentence should be awarded in rarest of rare cases after a thorough consideration of mitigating and aggravating circumstances. Because the appellant here had no criminal history, had good relations with his family before the incident, and other mitigating circumstances were not considered by the courts below, the bench comprising Justices Vikram Nath, Sanjay Karol and Sandeep Mehta, relying on precedents, deemed it appropriate to commute the death sentence to a life imprisonment without remission, which means that the appellant here will have to spend rest of his life in the jail. The appellant was a bank manager working with the PNB who was married and had two children. He was unhappy with the life choices and behavior of his sister-in-law and objected to her relationship with a co-worker. He used to tell his wife to ask the sister-in-law to change her ways, but his wife did not support him. To teach them a lesson, the appellant killed the sister-in-law and her mother. He then decided to kill his children and commit suicide. He took his children aged 10 years and 3.5 years and drowned them in a water tank. This present conviction was related to the killing of his children, as he was tried separately for the murders of his sister-in-law and mother-in-law. The court did acknowledge the barbarity of the crime and the helplessness of the children who were killed by their father, however emphasized that death penalty should only be imposed in the rarest of rare cases after considering all mitigating and aggravating circumstances.